My name is Lewis Stratton. I'm the Director of Stratton Safety. If you run or own a small business or a medium-sized business, I'd like to talk to you about work health and safety and the implications for you. You need to know a little bit about the work health and safety legislation, what the duties are and who holds a duty under the legislation. Why is it important to be systematic and proactive in work health and safety? Do you need to be third-party certified? How do you manage plant, machinery, substances and structures in the workplace? What about construction projects? And then how do you make a work health and safety system that really meets your responsibilities?
Being in England for many years now, I understand, all of you, and myself included, we all have to live under the weird and oppressive regime of health and safety regulations. Which is very strange, isn't it? Because, you know... Remember in the old days before health and safety? Remember when it was called common sense? Remember those days? Remember many years ago when you used to go, look, there's a great big deep hole. Will I step in it? No, I'll just walk around it like that. Well, how'd you manage to learn to do that? Well, my parents taught me not to be a moron. And I just kind of carried it on from there. See, the Dutch, they'll treat you like an adult. You're in Amsterdam, you're in a city. They sell pot, they sell mushrooms, there's trams, there's buses, there's cabs, there's push bikes with women, with kids strapped to the front of them. There's a road next to a canal. Is there a fence? No. No fence. England, there'd be a big sign, big fence, don't go in the water. Don't all fall in the water and drown, don't go in. Amsterdam, is your bike wet? Yeah. Well, you're on the wrong bit, mate. So...
Safe Work Australia provides some really useful data on the types of industries that we have and the work health and safety issues that face them. If we look at this graph here, we can see that agriculture, forestry and fishing, transport, postal, warehousing, construction, manufacturing and mining all figure fairly highly in the injury statistics. This table provides a similar picture with a little bit more up-to-date information. So if we look at the second column and the third column along, or the last column, you can see that again transport, postal and warehousing are near the top. And if we look at the column dated the 1st of January 2017 to the 30th of March, you can see that 18 fatalities have happened in that 3 months for the industry. Agriculture, 10 fatalities. Construction, 8 fatalities. So again, these industries remain at the top of the high-risk ventures. Let's just have a really brief look at the legislative framework for work health and safety. At the very top of the pyramid, you can see the Work Health and Safety Act. That talks about who the duty holders are, the duties they owe, some principles that are important to the legislation, and some information about how legislation is enforced. The Work Health and Safety Act is mandatory. So anybody running a business, big or small, you have to comply with the Work Health and Safety Act. When we're talking about the Act, one of the easy ways of referencing information is we look at the bold headings next to a number. Say, for example, the number 19, that's section 19 of the Act. We call those sections when we're talking about the Work Health and Safety Act. On the next level down, you can see Work Health and Safety Regulations. This really is a bit of a how-to guide for the Act, and it gives you some practical guidance on a whole range of topics. For example, there's lots of information about managing plant and structures, machines, chemicals, diving work, asbestos, and so it goes on. So they're quite practical in their application. Like the Work Health and Safety Act, these are mandatory for everybody who's involved in running a business. When we're referring to the regulations, again, there are some numbered headings with bold headings, and we talk about those being regulation number, and then whatever number we are particularly referring to. So Work Health and Safety Act and Work Health and Safety Regulations, they are mandatory. Underneath the work health and safety regulations, there's a level called codes of practice. So Safe Work Australia has developed some national codes of practice around work health and safety matters. Now these are not mandatory, but they are guidance information that businesses can use to manage particular hazards as safely as possible. Codes of practice are interesting in that although they're not mandatory, if you face prosecution as a business owner for some safety breach, Safe Work SA can actually go into a court and they can tender the code of practice as evidence of how they think the work should be done. So a court can consider that and judge your performance against the code of practice. So not mandatory, but probably important that you know what's in there and that you seriously consider implementing them in your workplace. It's sort of at the same level of codes of practice. There's also things like Australian standards and building codes and those sorts of things. Now they're not mandatory in terms of work health and safety unless they are mentioned in the Work Health and Safety Act or the Work Health and Safety regulations. So for example, in the regulations there's quite a bit of information about commercial diving. And that makes a reference to some Australian standards in relation to diving, so those standards become law because they're mentioned in the regulations. Underneath the codes of practice, then there's a whole level of guidance material. Again, this is not mandatory. It can't be tendered to a court as evidence of how something should be done, but both Safe Work Australia and Safe Work South Australia have a whole range of guidance material on a whole range of topics that is very, very useful to employers. So for example, a guide to managing fatigue in the workplace will be an example of some guidance material that's available to everybody freely. When we're looking at this slide, we're looking at who holds a duty under the Act. So one of the duty holders under the Act is an entity called a person conducting a business or undertaking, or a PCBU. Now, the previous legislation used to talk about employers and employees. The Work Health and Safety legislation does not use that language. So an employer is a type of a PCBU, but there are other types of PCBU as well. And this is just really reflecting the fact that we work differently now than we did 20 or 30 years ago, and the legislation has to keep pace with that. Some of the important things to understand about a PCBU is that it might actually be a natural person or a human being, or it could be a legal entity like a company or a government department or so forth. It doesn't really matter whether the business or the undertaking is for profit or not for profit. A PCBU is still a PCBU regardless. Now, a PCBU, as you can see from the chart, that includes employers, it includes sole traders. So Lewis Stratton, me, as a consultant for Stratton Safety, director of Stratton Safety, I'm a sole trader. I'm a PCBU. It includes corporations, associations, partnerships, government entities and public authorities, some volunteer associations, we'll talk about that more in a minute, and also trustees of a trust. So there's a whole range of examples that come out of Section 5 of the Work Health and Safety Act. Now, who is not a PCBU? So that's somebody who's engaged solely as a worker or as an officer. So they're not running their own business, they're working for somebody else typically. Elected officials are not PCBUs. So state government ministers, federal ministers, local council officials, they do not fall within the definition of a PCBU. Volunteer organisations that do not employ workers are not PCBUs. So when we say before that some volunteer associations are PCBUs, pretty much the moment they employ somebody, maybe a cleaner, a gardener, anybody doing any kind of function on a paid basis, that will make that volunteer organisation a PCBU and subject to the legislation. Another entity that's not a PCBU is a strata title body corporate responsible for common areas used only for residential purposes, so long as the body corporate does not directly employ workers. So again, there's that link between employing a worker and suddenly finding that you're a PCBU and that you have to meet the requirements of the legislation. So it can be quite a complex area. So another duty holder under the work health and safety legislation is a group called officers. So each PCBU will have one or more officers. Now officers are people, so they're actual human beings and they are personally responsible for work health and safety. So they can be fined. They can also serve prison sentences for serious breaches of the legislation. So who is an officer? You can see there it's a director of a secretary of a corporation, a corporate decision maker, somebody with the capacity to significantly affect the financial standing of the organisation. It might be an officer of the Crown, a government entity or public authority, somebody in charge of one of those. It could be a receiver, a liquidator or a trustee. So you're considered to be an officer if you come within the meaning of Section 9 of the Corporations Act 2001, so it's worth having a look at that when you get a chance. Or you're an officer of the Crown within the meaning of Section 247 of the Work Health and Safety Act, or of a public authority within the meaning of the section of 252 of the Work Health and Safety Act. The thing about officers are they must ensure the PCBU meets its duty of care. This is especially important when the PCBU is not a human being, when it's a corporation or a legal entity. It's probably important to have a pretty good understanding who is not an officer. So if we think about typical organisations, HR managers, site work health and safety advisors, these people are not officers in terms of the work health and safety legislation. Partners who are in partnerships, government ministers and elected members of local government, again, not officers in terms of the definitions in the Act. So if we were to think of maybe a couple of really key indicators of who is an officer, think about people who are actually involved in making governance decisions for either the whole organisation or a substantial part of the organisation. And think about people who could have a really significant financial impact on an organisation by the decisions they make. Because if they meet those two criteria, there's a very good chance that they are officers under the legislation. There are two other duty holders under the Work Health and Safety legislation, and I'm referring to both of them on this same slide. So workers are a category, and then others is the fourth duty holder under the legislation. So let's look at workers first. And if we look at the little diagram on the side, workers can be employees, they can be contractors and subcontractors, they can be employees of contractors and subcontractors, labour hire employees, outworkers, apprentices, trainees, work experience students, and volunteers. So all of these people come within the definition of a worker under the Work Health and Safety legislation. Now, their obligations is to look after their own health and safety and the health and safety of others, exercise reasonable care in doing that. They have to comply with reasonable instructions given by the PCBU. And for workers, they've got to cooperate with any reasonable policy or procedure of the PCBU. So it's in terms of the legislation, workers and others probably have the easiest duty of care to fulfil in the workplace. Now, just thinking a little bit more about who are the others. If we think about people who are not involved in conducting the work of the PCBU, it could be people like visitors, clients, patients in a hospital, those sort of people who are there for incidental reasons. So that's who others are. The Work Health and Safety legislation also has some really important principles that underpin how it works. So on this page here I've just listed several of them. It's not all of the principles. But for example, a person, and we are talking about either a PCBU or a human being may hold multiple duties. So again, if I use myself as Director of Stratton Safety, I'm a PCBU. I'm also the officer of the PCBU, and I'm a worker because I'm in the workplace conducting work for a PCBU. So I have all of those three duties of care. Another principle is that persons might have concurrent duties of care, in other words, shared duties of care. And a good example of that would be a construction site where you may have somebody in charge of the site, and whilst they're organising how things happen, you might have plumbers coming on site, electricians, excavators, and a whole range of other contractors, and all of them are bringing their own risks to health and safety onto the site, and they need to cooperate with each other to reduce those risks to each other's health and safety. So there's a shared duty of care there under the Act. One of the other things that's really important for people to understand is that if you have a duty of care under the Work Health and Safety Act, you cannot delegate or transfer that to somebody else. So the Act is very, very clear about that. That remains with you, and you will be the person who will be held accountable for that specific duty. Talking about PCBUs in particular, they must manage risk to health and safety as far as is reasonably practicable. So looking at sections 17 and 18 of the Act, that is their obligation, and it's a really fundamental obligation for PCBUs. Reasonably practicable, that's probably a little workshop in itself, but if you come across a hazard or a safety hazard in the workplace, you think, what are all the possible things that I might do to resolve this issue? And then under the circumstances, what might be reasonable? Just by way of example, if there's a health and safety issue that might cost 400 grand to fix, that might be deemed reasonable for a large multinational corporation, but for Lewis sitting in Stratton Safety, that might be considered not reasonably practicable, and Stratton Safety might have a case to say that's a control that we can't implement because of the disproportionate cost. This is a really useful little table that was developed in 2009 when the current Work Health and Safety national model legislation was being put together. So if we're looking at this table in front of us here, the middle column talks about the duties of care. So the primary duty of care is what the person conducting the business or undertaking it owes to workers and other persons in the workplace. So we're talking the PCBU there. If we look to the left of the PCBU, the nature of their activity is they're responsible for operation of the business or undertaking. It happens because they're in charge of it, they're making it happen. So if we think about what's the standard that a PCBU will be held to, we just look across at the right hand column under relevant standard, and their standard is reasonably practicable. So as I said before, what under the circumstances could be done, and under the circumstances what would be reasonable to be done to manage a health and safety risk in a workplace. Looking at the second row down, we're looking at officers and their duty of care. Now if you look to the left, we see that officers are involved in organisational decision making and governance. So it really is that sense of them being in charge of the direction an organisation is taking, being in charge of decisions that are being made. Looking to the right hand column, what is the standard, the legal standard that they will be held to? They will be held to the standard of due diligence. So for officers, section 27 of the Act talks about what due diligence looks like. So we'll come to that in shortly. Looking at the third row down now, we're looking at workers. Across to the left, we can see that workers, the nature of their activity is work activities, including supervision and management of other staff. That's part of the working scenario. And the standard of care that they legally owe is reasonable care. At the very bottom there's duty of care for others at a workplace and of others at a workplace, and that's the idea that I talked about before, where it's circumstantial attendance at the workplace, it's, visitors, patients, clients, those sort of people, and again, they owe the duty of reasonable care. So if a PCBU gives them an instruction to do or to not do something for safety reasons, they are obliged by law to comply with that reasonable request. I'm not going to spend a lot of time talking about penalties and fines and jail terms and so forth, but it is important to know that those penalties are there. So if we look at the chart in front of us and we look at Category 1 offences, those are offences that involve reckless conduct. So where something is so obviously unsafe and so obviously shouldn't happen, that it's reckless in nature. And if we look at the chart, there we can see a corporation or a PCBU can actually be fined up to $3 million. An officer working at PCBU can personally be fined up to $600,000 and get 5 years in jail. And if a worker is being reckless, so if we think about some examples where there's these initiation activities that are highly dangerous, it's conceivable that a worker might be punished for that. Then a worker could face a personal fine of up to $300,000 and 5 years in jail at a Category 1 level. Now, Category 1 is an offence where there is the potential to cause death or serious illness or injury to somebody in the workplace. Category 2 also has a potential to cause death or serious illness or injury to a person in the workplace, but it doesn't have that reckless component to it. So clearly a serious breach of duty of care, but just not as serious as the reckless conduct. But again, if we look at the corporations or the PCBU, they've got a maximum fine there of $1.5 million under the legislation. Officers could face a personal fine of $300,000. And a worker could face a personal fine of $150,000. Category 3 offences are a little different in that they actually do not involve the risk of death or serious illness or injury to a person in the workplace. So they tend to be around compliance issues. And for example, it might be that a PCBU says to a health and safety rep that no, you can't have the training that you're legally entitled to. That would be a Category 3 offence. And there'd be many other sort of category offences we could look at as well. But again, when we look at corporations, maximum fine of $500,000. If an officer is guilty of that kind of offence, a maximum fine of $100,000, personal fine. And workers could face a personal fine of $50,000 under the legislation. There are other kinds of enforcement activities that don't involve going to court and being convicted and so forth. I won't spend a lot of time talking about them, but there is something called an enforceable undertaking, where there is an agreement between a PCBU and the regulator to engage in a certain range of activities, and part of that deal is that they won't be convicted of an offence. There's also expiation notices, a little bit like your speeding tickets. So you could go to court and get a fine, or a regulator for work health and safety could actually require you to pay an expiation notice, less money, but you don't go to court and there's not a conviction recorded against your name as a result of it. So again, quite a complex area. You don't need to at this stage know all of that, but kind of helpful to know that that's there in the background. In my work, I often talk to officers and to PCBUs about being systematic and being proactive in terms of work health and safety. Now, that's not just a little quirk of my professional background. It is actually an expectation that arises from the legislation itself. So let's be clear that there's nothing in the legislation that says that a PCBU has to be certified against a standard or have a third-party certification. And the sort of standards that people sometimes will be certified against would be the Australia-New Zealand 4801 occupational health and safety management systems, or the standard 14001, which is about environmental management systems, or 9001 quality management systems. So they're relatively common, and big business quite likes to be certified against them because that says good things about their processes and the way they approach their work. However, just from a legislative point of view, if we're looking at section 19 of the Act and then also section 46 to 49, it does require things like the provision and maintenance of safe plant, structures and systems of work. It requires monitoring of conditions at the workplace, and it requires consultation, cooperation and coordination with other duty holders. So what else is there about the legislation that would suggest we should be systematic and proactive about work health and safety? If we look at the Officer's Duty of Care in the Work Health and Safety Act, so again section 27, it emphasises things like legislative compliance. It talks about acquiring knowledge, so knowing your stuff. It talks about understanding the business and the related hazards and risks that arise from the operations of that business. But it also talks about having resources and, significantly, processes for eliminating risk, receiving information about and managing hazards and risks, and complying with any duty or obligation under the Act, and then, really critically, verifying that all of the above is working. So that is really describing quite clearly a systematic and a proactive approach to work health and safety. It's a very clear expectation coming out of that section of the Act. If you are an officer in your workplace, that little grey box to the right there is particularly worth paying attention to, because that says the things that get a special mention in section 27 are notifiable incidents. So that's incidents that causes death or serious illness or injury. It could be the major collapse of plant, like a crane collapsing. It could be a ceiling collapse. It would include things like hazardous chemicals, exposure to workers to hazardous chemicals. There's a whole range of things that it's worth reading about that are notifiable incidents. That gets a particular mention in the legislation section 27. It also talks about consultation. It also talks about compliances with notices issued under this Act. So that would be when an inspector comes and issues either an improvement notice or a prohibition notice. The officers will be held to account for making sure those are attended to. Special mention for training and instruction to workers about work health and safety. And special mention of health and safety representatives receiving their training entitlements. So if you do nothing else as an officer in the workplace, you better make sure those things are ticked off and are working well in your workplace. There are other reasons you might want to be systematic and proactive in work health and safety. As this slide suggests, you might have entities who are funding project work that you're involved in, and they might have a requirement that you meet certain standards, or you have certain certifications, or that you meet certain criteria that they have. There might be that third-party expectation of you to have a health and safety system in your workplace. If you're involved in working with government agencies, whether it be local, state or Commonwealth, they might also require you to have a health and safety system of some sort. It may not be a certified system, but they will describe what it is that they require. One of the other things that's really useful to know about government entities is that sometimes they will have other requirements. So for example, I was involved in a Commonwealth funded project not so long ago, and one of the requirements of the Commonwealth Funding Agency was that the PCBU made sure that they supported the freedom to associate. In other words, their workers had to have the freedom to be affiliated with the union. Another reason that you might decide it's important to be systematic and proactive about work and safety is if a large corporation is contracting your services to do something for them, they themselves might have some criteria about what they expect from you around health and safety in the workplace as well. On the right hand of that slide there's a little diagram, so it shows a little cycle from commitment, that's talking about leadership commitment to health and safety, And then there's a planning phase, then there's an implementation phase. Implementation is often what we see in a workplace. It's, you know, the workplace inspections, the testing and tagging, all of those activities that kind of people are familiar with. Then the next part of the process is monitoring, measuring and evaluating the performance of the system. And then the last stage is for senior management to review how's it going, what do we need to change, what do we need to keep, and making those kinds of decisions. Now that little cycle that's on the slide there, that pretty much comes right out of the Australian Standard 4801, but it would be a very similar process to other standard type systems as well. We're just going to have a little change of pace here, because what we're talking about on this slide here, managing hazards and risks systematically, is actually dealing with hazards that you can sort of see, hear, smell and touch in the workplace. So these little diagrams come straight out of the Code of Practice for managing health and safety risk in the workplace. The one on the left talks about 4 stages in the process. So first of all, you've got to identify the hazards. Hopefully that's because you've got a proactive system in place like workplace inspections, and it's not because somebody trips over something or falls off something and that's how you find out about the hazard. Step 2 is assessing the risks. So you're looking at what's the root cause of the problem and how likely is that to happen again, and if it does happen again, how bad are the consequences likely to be. Step 3 is actually controlling those risks. So what are you going to do to make it less likely or less serious for the workers who are exposed to the risk? And then step 4 is looking at, once you've implemented some control measures, when are you going to review them and just make sure that they're working as they should? Sometimes when you control a risk, the things that you do might actually introduce new hazards, so you have to just keep on top of that stuff and make sure that's not happening. You can see from that diagram that the centre at the core of it is management commitment, so that's a key expectation. And then around the edge, for every stage of that process, it talks about consultation, and that really means consulting with the workers who are affected by the hazard, and any other stakeholders as well. Now, if we look at the diagram on the right, that really relates to step 3 of the wheel, where you're controlling risks. Now, when you control a risk, you could do something simple like tell somebody to be more careful. You could put a sign up somewhere and, you know, warning workers of a risk. But you really want to pitch it at a much more effective level. So this graphic on the right is called the hierarchy of controls, and it's comes straight from regulations 35 and 36. So the most effective control that you can have is to eliminate the hazard altogether. So if something is broken, you get it fixed or you remove it. It's gone. Can't hurt anybody else. So that's a level 1. Clearly the best control out, because you're not relying on humans to change their behaviour or patterns to monitor their safety. The next level down in controls is level 2, and again these are quite effective controls. So if you can't eliminate the hazard, then if it's not reasonably practicable, then the next level down is to substitute the hazard with something safer. So quite often I use hazardous chemicals as an example. You might be using a hazardous chemical like hydrochloric acid or something to do a process, and maybe there is another less hazardous chemical you can use that will achieve the same outcome. That would be an example of substitution. You can isolate the hazard from people. Now that might be permanently, or it might be on a temporary basis until something else is resolved. And you might reduce the risk through engineering controls. So a typical engineering control would be putting a machine guard onto a machine that would otherwise be dangerous. But it can be many other things as well. So level 2, quite good controls, and it's reasonable to have confidence when those controls are executed well. Level 3, so the first item in level 3 talks about reducing exposure to the hazard using administrative actions. Now, administrative actions are things like telling people what to do, giving instruction, training them, putting signs up, all of those sorts of activities. And all of those activities, the weakness is they require people to actually implement the training, the advice, the signage, and to do as they're supposed to. Now, we can all probably think of times in our lives where we haven't followed the rules. That is one of the realities in the workplace, and that's why level 3 controls are not the preferred way to solve a problem. The very last section in level 3 is using personal protective equipment. So you're very much at the lowest end of the hierarchy, the least preferred option when you're talking about PPE in a workplace. Nevertheless, quite often you'll have controls, more than one control, and you might choose them from different levels in the hierarchy. So if I think about a machine coming into a workplace and the machine is hazardous, you might put an engineering control on, you might put a guard on that machine, but you might also train people how to use that machine in the safest manner possible. So using it to do the work, how do you maintain it safely, how do you store it safely, all of that sort of stuff. And you might also say when you're using the machine, you will wear this PPE, safety glasses or whatever it's going to be that you require. So it's quite reasonable, and it's also quite common to pick 2 or 3 levels out of the hierarchy of controls in relation to a particular kind of risk in the workplace. This whole managing hazards and risks, that is the engine room of a work health and safety system. If this part of the process is not done well, you will not have an effective approach to work health and safety in your workplace. So it's really important to get this working properly. This slide shows a flowchart that I've put together to kind of give some practical guidance about managing health and safety risk in a workplace. So if we look at the circle starting at the top, it talks about a hazard or a risk or a non-conformance is identified. Then you come to a decision point straight away. Has an injury occurred? So if the answer is yes, off to your right, you apply first aid, you deal with the emergencies, you remove bystanders, make the scene safe, and you might have to preserve the scene for a further investigation. If the answer is no, there's no injury, your next decision point is this a notifiable incident? So as I talked about before, that's really serious incidents or injuries in a workplace. If the answer is yes, you must notify the relevant regulator. So in South Australia, if it's a work health and safety issue, then we notify Safe Work SA. If it's an issue to do with, say, plumbing or gas or electrical infrastructure, we'd notify the Office of the Technical Regulator. If it's an incident where there's the release of hazardous chemicals into the environment, then we would also notify the Environmental Protection Authority about that matter as well. Now, if it's not a notifiable incident, then we look at can known controls be applied. So if somebody has just simply not implemented a procedure that has been developed and implemented and trained, they've just not done it, then the solution is obvious. You apply the known controls. You might also need to, or management might need to think about how they deal with that person who has not implemented the required procedure as well. Now, if the known controls can't be applied, then we need to make sure that the hazard or risk is reported using whatever system your organisation uses. Now, before we follow down that little line of reasoning, I'm going to go back up to the first aid box where we looked at applying first aid, and also the box where we talked about notifying the regulators. You'll see some little dotted lines that come out of those boxes, and they come down and meet the chart at the point where we're now reporting the hazard or risk using the organisational reporting system. So the point I'm making here is just because you've applied first aid or chuffed somebody off to hospital, or just because you've notified the regulators, it does not let the PCBU away with actually managing that hazard or risk in the workplace. So here we are, we're now reporting it. The next stage of the process is that an investigation needs to take place. Now that is a management responsibility, and the investigation should really be looking for the root causes, what's underlying the hazard, and getting right to the bottom of that. They need to assess the level of risk to workers and others. So how likely is it to happen again, and how bad will it be if it does? And then they need to implement appropriate controls using the hierarchy controls that we talked about before. Going straight down the list, at some point management need to lead a review of the effectiveness of controls. Now if we look just to the right of the diagram, there's a little box there that says managers in consultation with workers and or health and safety representatives. So that means a manager who is investigating a hazard or a risk, they should be talking to the workers involved, and they should certainly be talking to the health and safety reps who represent those workers if there is such a person in the work group. Okay, now if we look at that second to last box about implementing appropriate controls, one of the things that you might find after you've implemented controls is that there is still a residual risk after you've added some more control to the hazard. So I would be suggesting that if there is a moderate or a higher level of risk once the controls are applied, that should be noted on a strategic hazard or risk register somewhere in the organisation, and that is something that senior management, officers in the organisation should be looking at periodically, at least annually, to see if they're still applicable and maybe to see if there are better ways of managing that risk in the workplace. I'd like to spend a little bit of time talking about a PCBU's responsibilities in relation to work health and safety. And essentially, PCBUs have responsibilities for things that they have management control of. They've got responsibilities around plant and equipment. They've got responsibilities around substances or hazardous chemicals. And they've got responsibilities around structures in a workplace. So if we're looking at Section 19 of the Work Health and Safety Act, that talks about a PCBU having the responsibility to ensure, as far as is reasonably practicable, that workers and others are not subject to risk to their health and safety. So that's called the primary duty of care and is a significant part of the legislation. Section 20 of the Act talks about PCBU who has management control of a workplace. So that might be they either own the building or the premises, they might lease it, they might rent it, but on a day-to-day basis they've got management control of the place and what happens inside that place. Section 22 of the Act talks about a PCBU having responsibility for fixtures and fittings in a workplace. So again, the same idea. It falls within their sphere of operation, and so clearly they've got an obligation to manage the risks that arise from those kind of things. Once we get into Section 22 and right through to Section 26, the words plant, substances and structures get repeated over and over again. So in those sections of the Act, and it's worth having a good read of them, it talks about PCBUs might be involved in commissioning work or commissioning activity. So there are some responsibilities that come out of that. They might be involved in designing. They might be involved in manufacturing. They might be involved in importing, supplying. They could be involved in installing, constructing, or they might be involved in decommissioning something. Once it's a item of plant, for example, once there's no use, then they have to think about a safe way to dispose of the plant so that it won't cause risk to other people. So when we're talking about Section 22 to 26, in a way I tend to think of the chain of supply. Sometimes the PCBU might do more than one part of that process, and sometimes they'll do just one part of the process. But the idea is that for their part of the process, they need to manage the risk that's involved in it, but they also need to communicate with the other duty holders. So if they're passing on a risk, they need to tell the other duty holders about that residual risk that is there to be considered. The regulations then elaborate on those kind of responsibilities in great detail. So as I said before, there's a big section on plant and structures, big section on chemicals in the workplace. This part of the Act, sections 22 to 26, kind of lays the groundwork for some of that later on in the legislation. There are so many parts of the Act and the regulations that are important to workplaces, but I'm just going to focus briefly on construction, because there are some really particular things around construction that make it quite tricky in terms of legislative compliance. So when we look at the legislation about construction, it talks about a construction project. The Work Health and Safety Regulation 292 kind of describes a construction project as something that's over $450,000 in value. Construction involves obviously making structures. That includes things like roads and buildings and all sorts of things. You can read more about that in this section of the regulations as well. But if it is a construction project, and if it, being over $450,000 in value, then there needs to be a principal contractor who has management control of the workplace and fulfills a whole range of responsibilities. That's something that's very easy to overlook for people who are not well versed in the legislation. But the consequences of doing it are really severe. The penalties are severe, and the potential for things to go wrong in the workplace are also really high as well. The other thing to look at in terms of construction is it high risk construction? So again, working at heights would be an example of that. There's a whole range of things that make certain types of construction high risk. If the answer is yes, then the people undertaking that work, they need to develop and they need to work to a safe work method statement. So a safe work method statement has a really particular meaning in the regulations. Let's just focus a little bit on principal contractor responsibilities under the legislation. So whoever commissions the work, or the PCBU that's commissioning work, they are the principal contractor unless they lawfully delegate this to another PCBU as described in Work Health and Safety Regulation 293(2). So there is a way of doing that that's legally permissible, but the principal contractor must have management control of the site, be provided with information about hazards and risks by whoever is commissioning that work, to the best of their knowledge. They must manage risks as far as is reasonably practicable, including unauthorised access to the site. So, we all know that building sites and construction sites are subject to vandalism and theft and all those kinds of things. The principal contractor actually has to think about the health and safety risk of persons when they're entering those sites after hours. They've also got to ensure that safe work method statements are prepared where relevant and implemented by contractors. The principal contractor must also keep copies of any safe work method statements. They must review them if relevant control measures are revised. They must keep records of notifiable incidents for 2 years, especially in relation to high-risk construction work. They must obtain current underground essential services information if that's relevant to the work being done. They must ensure installation of appropriate signage in the workplace. For example, who is the principal contractor? Who are the other people on site doing other sorts of key functions like, wardens, first aiders, health and safety reps, that kind of thing. So that's the principal contractor's responsibility. And they must also prepare, communicate, review and keep a work health and safety management plan. Just thinking about the things that we've discussed so far, we've been talking about what the legislation says and what it requires. And we've been talking about a systematic approach to work health and safety and being proactive about work health and safety as well. So all of those things kind of lead in the direction of having some kind of system, some kind of structures in place to manage safety effectively. This little diagram looking on that we're looking at on the slide here, it just provides a way of looking at what a system might contain. So at the very top, you've got a work health and safety and injury management policy. So that's where a PCBU makes a commitment to health and safety, and if people are injured, makes a commitment to helping them return to work. So a bit of a general statement about their intention around work health and safety. At the next level down, depending on the size of the PCBU, there might be some corporate procedures. So in bigger organisations, if you had a corporate procedure, say for example on occupational violence, that might say things like if you have a genuine fear for your health and safety, you must report it to the police. and then at a local level that might be built into SOPs or safe operating procedures relevant to the context there. So corporate structures, corporate procedures are one level of documentation, particularly large organisations. At that level as well, you might think about what are your system key performance indicators and what measures will you use to test the effectiveness of your system over time. At a more operational level, work health and safety systems will have things like registers, say chemical registers, asbestos registers, a register of approved contractors. Be a whole range of things. It'll also have schedules. Testing and tagging comes to mind. Workplace inspections comes to mind. All that sort of stuff. At this level of the system, we might be looking at job safety analyses or job safety environment analyses. Hazard incident risk assessment type of documents. So those sorts of documents that really look at a task and break it into steps and think about what are the risks associated with each step, how we fix them. Risk assessments generally. So often I think in terms of you'll be risk assessing plant machinery, you'll be risk assessing hazardous chemicals, you'll be risk assessing processes in the workplace, for hazardous manual tasks, for example. So a whole range of risk assessments. And you'll have a whole range of forms and checklists in there. So workplace inspections, usually that's a checklist kind of activity. In terms of forms, you'll certainly have some kind of hazard and incident reporting form, but there'll be a whole range of things that make sense for that part of the system. Also at this operational level, you might be having safe operating systems that break a task into step 1 through to whatever, and explains to workers how each part of the task is conducted, and outlines the sorts of hazards that they might be facing and how they should deal with that. Depending on the nature of the PCBU, you might also have some project management documentation. So if you're out there doing construction projects in different places, different times, that's probably a little part of the system that will have a life of its own. So when I was talking before about a principal contractor being responsible for a work health and safety management plan, that would be an example of one kind of bit of documentation that would sit in that part of the system there. So that's kind of how it looks, and the sorts of paperwork that you would see in a system. And of course, for that system to be effective, it has to be implemented, has to be monitored and measured, and senior management need to kind of check on its health on a regular basis as well. So if you own a business, or you're responsible for running a business for a PCBU, how do you know what kinds of hazards your workers might be exposed to? How do you know what you should be considering inside your system? The answer is it's as long as a piece of string, really. There could be all kinds of things. But on this slide here, I've just put up some things that you might be exposed to in the workplace, or your workers might be exposed to in the workplace. And maybe you can look at this list and you'll see, you know what? We need a bit better coverage on this element or that element of the system, and then consider how you'll plug the gaps in your own approach to health and safety. Now I've grouped them in broad headings, so hazardous chemicals and dangerous goods, environmental hazards, plant and equipment hazards, that's a big one usually. And when I look at the convictions lists in the Safe Work SA website, roughly half of all convictions are to do with machinery, and that often means it's machinery that's not guarded or not maintained well. I've also got a category for people or behavioural hazards, because that's very common in workplaces, and then other physical hazards, so electricity, working at height, gravity some people call that, inadequate procedures or risk assessments, handling animals perhaps, and so on. So that might just help kick off your thinking about, are there risks that we just deal with on a regular basis that we haven't thought enough about, and that maybe we need to formalise in terms of either training, an SOP, or some other approach to health and safety. So thanks for listening. I'll leave that with you, and I'm certainly very happy to take questions from people. You can email me at Lewis, Lewis, @strattonsafety.com.au. and I will respond with pleasure. So thanks again for listening, and all the best in your endeavours.